NYU law professor Melissa Murray, Mary McCord, a former acting assistant attorney general for national security at DOJ, and Andrew Weissmann, former FBI general counsel and a Mueller prosecutor. Mary and Andrew also co-host the MSNBC Main Justice podcast. And if we wanted to pull out Wikipedia, we could add many more details and accolades about all of your careers. Welcome. Andrew, your thoughts tonight.
So I was thinking when you were talking that one way that I try and think about this is divide things into the illegal, another group is the incompetent, and another group is the unwise. And it's worth sort of remembering that third bucket. There are a whole bunch of things that are going on that are legal. They just are things that I think many people would find to be sort of outrageous or improvident. I mean, just start with day one, which is pardoning people who assaulted our democracy, but actually also assaulted law enforcement. Then there's this bucket of just the incompetent. Abrego Garcia, could be an example of that. The claim that the Harvard letter was a mistake, which I think is palpably not true, given subsequent actions. But remember, the defense of what happened there is the government saying, oh, no, that was a mistake. So that would be gross incompetence as the defense of doing something that Harvard says is illegal. And then the thing that we spend a lot of time on is things where the courts have actually said over and over again, this is illegal. But I think it's useful to put it in the context of a number of different things that could be legal, but just, in my view, outrageous, that in terms of what the administration is doing. So I think it's useful to think about that in terms of all three of those things going on.
And you left out one that we've talked about on the podcast, cruel. Just cruel, right? Some of these things might be lawful, might be unlawful, but they're with a malevolent intent. And I think an intent to really create multiple tiers of people in this country. And particularly targeted at immigrants, whether lawful or unlawfully here, but also at the LGBTQ community and really sort of anything other than white men, honestly. But on the illegal part, I think one of the key things here that we've just never seen in anything like this magnitude is the steamrolling the other two co-equal branches of government, right? Plowing right over congressional statutes, dismantling departments and agencies that not only Congress statutorily created, but a president signed those statutes that created those departments and agencies, right? Ignoring appropriations that Congress, under the spending clause, had the constitutional authority to appropriate for certain purposes and just cutting off that funding. So lots of times just ignoring Congress. But also now we are up against the very edge, if not having crossed over into violating court orders too, which then then we're talking about trying to steamroll the judiciary.
And Melissa, when you talk about that steamrolling, the political messaging over the legal clashes is almost joyous or cartoon villain style. Take a look at Carolyn Leavitt from earlier this week.
Would you ever arrest somebody higher up on the judicial food chain, like a federal judge or even a Supreme Court justice?
That's a hypothetical question. Again, I defer you to the Department of Justice for individuals that they are looking at. So anyone who is breaking the law or obstructing federal law enforcement officials from doing their jobs is putting themselves at risk of being prosecuted, absolutely.
You heard it there. They know exactly what they're doing. We haven't really covered this that much. I don't know that many news outlets have covered it. But last week, America's First Legal, which is Stephen Miller's legal outfit, not an arm of the administration per se, but certainly in league, I think, filed a lawsuit against John G. Roberts, the Chief Justice of the United States, in his capacity as the chief administrator of the Federal Judicial Conference. And the whole idea behind this lawsuit is that the Federal Judicial Conference, which has always been the administrative branch of the federal courts, is actually a part of the executive branch. And again, it seems wildly implausible that that is the case, but I think the point of this lawsuit is, like, we can do whatever we want to you. We can issue these threats against judges. We can say we're not going to abide by judges' orders, and we can also sue the Chief Justice and make him an actual defendant in his official capacity in a lawsuit. And, Mary made a good point about this administration essentially giving the double middle finger to both Congress and the courts. They've been doing that from day one. We don't talk about the TikTok case that much, but the court issued a unanimous opinion upholding Congress's bipartisan ban on TikTok, requiring TikTok to divest itself of Chinese ownership on the Friday before the inauguration. And the president-elect over the weekend said he had a better idea. He was going to do a deal. And to my mind, that was the first constitutional crisis. And we don't even really talk about that.
Why don't we talk about it?
Great question. I mean, we should be talking about it because it has been a harbinger of everything that has followed. It was the template for what we are seeing now, just the abject defiance of the courts and Congress on the sidelines.
So one of the things that, and you're such a Supreme Court guru, is essentially you have the administration in the Abrego Garcia case, just as one example, doing something that to my mind is, as our colleague Ryan Goodman said, it's sort of thrice denied what it is that the courts have said, whether it is the initial court saying do not send him to El Salvador, whether it's saying you have to give him due process, whether it's saying you have to facilitate his return. That's sort of the thrice. Is the Supreme Court going to stand up? I mean, the number one question we get, and I'm sure you get on your podcast as well, is what are the courts going to do? Because they don't have an army.
They don't have an army. I think one of the reasons why you saw the court's decision, the earlier decisions around Judge Boasberg's order, they initially said it should not have been filed in Judge Boasberg's court. It should have been filed in Texas, where the detainees were before they were expelled to El Salvador. And then they said that habeas was the appropriate vehicle to go forward. Real questions about whether you can aggregate habeas proceedings, like they're usually done singly. That means each individual detainee likely has to have their own lawyer in order to proceed.
Whack-a-mole, right?
Terrible. So,
right.
But I think part of it is like the court a little worried that this administration is not going to listen, and they're trying to find ways to kind of play out the clock a little bit. One thing, though, I do think is encouraging about the court's order that you mentioned, Ari, is, it was a 7-2 order. I think we ought to wonder why it wasn't 9-0, why Justices Alito and Thomas weighed in favor of the administration. But the fact that they issued that ruling at 1 a.m. and did not wait for Justice Alito to file his dissent, that came later, suggests that this court knows that the administration cannot be trusted. The presumption of regularity in the executive no longer exists.
So just unpack that a bit more, because when those stories break, Melissa, people say, oh, my gosh, 7-2 and the Trump appointees, and that's sort of the headline. And in my view, as both a legal reporter and lawyer, is that is the first headline, because you say, whoa, 7-2 and the Trump folks. But then underneath that is you're hard-pressed to find other modern examples in the last decades where, to distill what you observed, the court looks over and says, not only the president's leadership, but enough people now in the executive branch who might not have been there in 2017, when you think about the range of purging, can't be trusted. In other words, are either bad faith actors, so they're going to find a way around complying, or are full-blown liars, which in court we call perjury. What did that mean when you saw that, and how does that affect what you expect the Supreme Court to do in the next few months? And then Mary.
I'm done predicting what the Supreme Court is going to do, full stop. But I do think that did raise eyebrows. The fact that they issued that at 1 a.m, they have a pretty, I wouldn't say leisurely, but they keep business hours, right? To do something at 1 a.m. was highly unusual. Not waiting for a noted dissent from one of their colleagues, also highly unusual. It was because they knew time was of the essence. If they did not issue that order immediately, who knows what the administration would do.
In fact, just to be clear just how dramatic that was, on the Friday night, one of the government lawyers had said to Judge Boasberg, a district judge, we will not do anything today, but I need to tell you we're reserving the right to do something tomorrow, which means 12:01. So in terms of thinking about the sort of TikTok of what was happening, the Supreme Court knew that if they did not act immediately, those planes could have been taking off, and that all these people could end up in El Salvador with the government saying, we wash our hands of it.
Two more points on this. We've emphasized 7-2, but there was one part of this where everyone was unanimous, even in Justice Alito's dissent, joined by Justice Thomas. At the very end, after he objects to doing an emergency, middle-of-the-night ruling without hearing from the government, without the lower courts having gotten a chance to have it percolate and rule on it, he makes clear the executive must obey our order of April 7th, which was the order that says you have to provide due process, notice, and an opportunity to seek relief in the court. So remember, all nine agreed to that multiple times, and I just want to keep flagging that over and over. Now, at some point, the decision will be how much process is due, and that's where some of the justices might fracture. The other point is this is still on hold because the Supreme Court said, the seven there said, no further deportations of the putative class from the northern districts of Texas until further order of this court.
Mary, you look at that all together and you realize on many days of the first 100, the lead thing in a substantive way, and I don't mean the media, I mean the most important thing sometimes happening in the federal government was a clash between branches over fights the administration picked that any working lawyer, Federalist Society or otherwise, would have told them in advance, you probably don't have this power.
Well, that's one of the remarkable things here, because so many things he's done, he would have needed in an ordinary world to go to the Office of Legal Counsel at the Department of Justice and get a legal opinion on that. Well, he did these things so fast and furious. Number one, I don't think there was even time for that if he wanted to. And secondly, it appears that he's just sort of not paying attention to that office. I mean, there are political appointees in that office, and so it always just change policy-wise, administration to administration. But there is no one giving him the advice he needs to stop completely walking into losses in court, or he's ignoring the advice. You know, it could be a combination of both. And it could be he doesn't care because he seems to be prepared to lose in court. And that's where we're, pushing to what's going to happen.
I think that's exactly right. He is prepared to lose in court. And I think the attacks on the judges are to lay the groundwork in the court of public opinion that the judiciary doesn't actually matter. He keeps harping on this mandate, essentially telling the public, you voted for this, you voted for me. That's the only thing that matters. That's the rule of law, not what these judges have to say.
And I want to bring Andrew in, but put some of the numbers on the board. I mentioned that the courts will say we only do law, but other things can matter. We've seen wartime impacts. If you look at the 100-day approval, Donald Trump doesn't have a strong hand. If you separate the bluster and we look at the actual approval numbers, it is 39%, the lowest in 80 years, including his first term. If you look at this Fox poll where you ask people about the issues, he loses on overall immigration, overall performance, guns, everything. Border security as a subset is the only place he can find a majority. And so, Andrew, does it matter that in a fight where the president says, hey, everyone supports this, that's not true, and judges can see, if they're informed, that he is fading after the first 100 days, not rebounding?
Look, the salvation here has to be the populace. I mean, the salvation is clearly not Congress, which has not been doing anything. The courts can only do so much. Remember, a lot of what we're talking about is something that may be illegal, but there's a whole lot that's going on that is legal and just improvident. And so that's where you really need those polls. I mean, that is why that is ultimately the key issue. But what we're seeing in terms of the attack on the judiciary, I mean, nobody should be surprised. This is, a man who is a convicted felon sitting now in the Oval Office. We saw him attack prosecutors and the courts for the entire time that he was under indictment. So now you're seeing the exact same thing. It's the reason he has attacked the media, anybody who stands up. And part of it, even when he loses, is fear. So the idea of attacking the law firms is that they have the fear they will obey in advance. The attacking of universities is so you have fear and obeying in advance, even if he loses. The international students, international scholars thinking twice about coming here. Scientists thinking, you know what? better to be doing this in Canada, in England, in France. I mean, the repercussions because of the nature of what he is doing, even if the courts ultimately say you can't do this, are enormous.
Andrew, as we try to deliver on what we aimed for tonight, the lessons going forward for the things that worked dealing with this Trump legal onslaught.
Let's learn from history is the way I look at this, which is all of us at this table were too young for the McCarthy era. But I think there are real lessons there for us, which is we are seeing blacklisting. We're seeing the same kind of abuse, the same kind of fear, the same kind of obeying in advance. And I think the lesson, if you think it can't happen again, it is happening now. The idea that, oh, that's something that's just in our history and we're well beyond that. No, that is what is happening now, not just blacklisting, but people going along with it, not being the people who stand up. And I think that is the lesson, which is if you want to be on the right side of history, you need to not be afraid. You need to speak. You need to be saying to people who want to use fear as a way to silence you that you still have a First Amendment right.
Well, it's the time for the people, right? I mean, you're showing the polling. We're showing more and more protests because the three branches of government, the executive is trying to steamroll the others. The judiciary is trying to put up roadblocks wherever it can. Congress is asleep, and it's time for the people to demand something more. And I think as we do get closer to 2026, we're going to see more and more and more of that. But in the meantime, it really is incumbent on the three branches to all do their part. And I just want to quote from Judge Royce Lamberth, a district court judge in D.C., appointed in 1987 by President Reagan, in ruling against the Trump administration just a few days ago, said, if our nation is to thrive for another 250 years, each co-equal branch of government must be willing to courageously exert the authority entrusted to it by our founders. And he said that after quoting from Federalist number 51. So he's saying, we're doing our part, Congress needs to do its part, and I'd say another branch, not really a branch, the people.
Yeah, and there are fundamentals there. And I know Andrew got a little concerned when you said you were going to quote, because he's very strict with music quotes. We've been doing this.
But I trust Mary.
Mary was fine. We've been doing this together for years, and he will patrol a quote. Okay. But once we got that it was Federalist Papers and judges, we were back on track. Melissa, yes. Close us out here.
So I agree entirely with Mary. Congress needs to get off the couch and get in the game. But I think the other thing we need to do is stop looking at all of these different episodes as sort of individual, isolated episodes. They're all part of a concerted strategy to close down every legal avenue that could be an engine of dissent against this administration. We have DOJ no longer enforcing justice. Like the whole dismantling of DEI, everything the DOJ has done thus far has been in support of this administration. They have attacked the courts to undermine the courts' trust with the public for when the courts actually do speak. They are attacking the whole prospect of the nationwide injunction, so it's going to make it harder for people to challenge the administration's actions. They'll have to do it in every different jurisdiction. That'll be entirely unwieldy. They are subjugating law firms, and they are trying to attack public interest firms, too. All of that is about reducing the amount of legal resources available for this fight. It is not a coincidence. This is a strategy to make the law no longer work for the people.